Atheist Nomads, episode 346, Fighting Crosses on Public Land with Monica Miller.
The podcast you're about to listen to includes cursing and talking about hoo-haws. Please be advised.
Welcome to another episode of Atheist Nomads. I am Dustin, and in a little bit, I'll be joined by Monica Miller, the Senior Legal Counsel for the American Humanist Association and the Appignani Legal Center for the American Humanist Association. A really good discussion about church-state separation fights that she works on every day at her day job. And at the very end, we talk about her other job where she works with the Nonhuman Rights Project. So she's fighting for humanist rights as well as rights for, not even humans. So yeah, she fights for rights, and pretty awesome, very impressively successful person, and it was a really good discussion, so I really hope you'll enjoy it. I'm going to keep the opening here pretty short because I am not feeling well, have a cold and a sore throat, and my voice probably sounds like crap, but the coronavirus, COVID-19, has reached full-on official global pandemic, and it is continuing to spread across the United States. How much? Nobody knows, because they're still not letting testing happen the way it should. As in, a doctor thinks you might have it, so orders a test for it. They've opened up testing quite a bit. They're trying to get some kits out to hospitals. Quest and LabCorp can test for it. Depending on your state, it's probably only if the state says that they can, which is complete bullshit. Considering the fact that I do work for a healthcare organization, I do at this point need to specify that I do not in any way speak on behalf of my employer, but this is bullshit, and they need to be, even if it's just for epidemiological reasons, we need to know how many people have this, and it needs to be more than just how many people are hospitalized for it, because it could spread through schools in towns and cities long before it starts killing people, because it's almost exclusively killing the elderly. So getting as much data as we can makes it much easier to track what's going on. But it definitely looks like the government doesn't actually want to track it. They want to pretend it's not happening. And that's really disappointing. And this needs to change. They've got test kits out there. They need to really work on upping the rate at which they are approving test kits, the commercially produced ones, so that they can be tested more places and faster. And, because if you can get it tested at a local hospital on a biofire, we're talking a couple hours, you've got results. That's a lot better than needing to send it to the state lab where they run it on a daily batch and it takes all day to get results out of it. So, or shipping it off to LabCorp or Quest, wherever they're going to be doing it. So yeah, they need to get this out everywhere. They need to do a much better job. But it doesn't look like the government actually wants to do anything about this and just wants to pretend it's not even happening. And that is bullshit. And it's an election year. So of course, Trump wants to make it look like he's winning. He's beating this. Numbers are low. Bullshit. This is a global pandemic. This is a disease that is out there. It is in the wild. It is everywhere. It's spreading rapidly. Soon will be everywhere. Realistically, just about everyone will get this, and a lot of old people will die. A lot of other unhealthy people will die as well. But we need to do a better job of at least tracking what's going on, if not actually trying to mitigate the spread of it, if for no other reason than to not overwhelm the healthcare system when it hits hard. But that's all I'm going to rant with on this for now. So it's time for the interview. All right, we are now joined by Monica Miller. She is the legal director and senior counsel for the American Humanist Association's Appignani Humanist Legal Center, as well as the executive director of the Humanist Legal Society, and has actually argued before almost half of the U.S. Courts of Appeal and the U.S. Supreme Court. Monica, welcome to Atheist Nomads.
Yeah, happy to be here. Thank you for having me.
Yeah, man, how have you pulled off a career like that?
Lots of Red Bull.
Yeah, because you graduated from college in 2008 and law school in 2012, and yeah, you're just rocking it.
Thanks. Yeah, no, I'm not kidding. I drink a lot of Red Bull.
All right, so out of all of this, I guess let's start off with your job with.
Yeah.
What exactly does the Appignani, if I'm even pronouncing that correctly, Legal Center do?
Yeah, so you're pretty much pronouncing it as Appignani, but it is the legal arm of the American Humanist Association. So it's not a separate entity from the American Humanist Association. And we focus all of our cases on the separation of church and state mandate that's embedded in the First Amendment.
Okay.
And so we argue cases in federal courts across the country whenever there is an infringement of, separation of church and state. In addition to litigating cases, we also send demand letters to governments, trying to give them an opportunity to reverse course before jumping into court.
Sternly worded letters.
Very sternly worded letters, yes.
All right. Yeah, I listened to opening arguments, so I know about that phrase.
Oh, yeah.
All right. And how does what you do differ from what FFRF does?
Great question. I would say that it doesn't differ that much. We actually work very closely with all of these sort of secular groups, FFRF, Center for Inquiry, Americans United for Separation of Church and State. There's only kind of a handful of us at each organization that is, that are focused on church-state separation on this side of the fence. Mm-hmm. And our opponents are just, they have so many more resources and attorneys. Beckett Fund. I mean, I could just go on for, ever about how many attorneys that we fight against. So in some ways, I guess to answer your question, in some ways I see us kind of as one kind of large kind of entity with different, attorneys at different organizations, but we work together so often that we sometimes feel like we're kind of in the same firm, if that makes sense. But we do take on cases. Yeah, that being said, we take on cases that sometimes are a little bit different from more the humanist perspective. So several of my cases that I've won have involved humanist inmates who are seeking equal treatment in the prison system. And in those cases, we argue that humanism should be treated like a religion. It's not a religion, but like a religion for, constitutional purposes. Those are kind of the cases that are a little bit more, a little bit different than just your average church separation case.
Now, with those ones, because that's come up. I know there was one of those recently in Oregon a couple years ago.
Yeah. Yes, that was our case. Okay,
yeah. So what was the basic premise there that you were trying to fight for?
Yeah, that's a cool. Unless there's another case that I'm not aware of since that one. I think I won in 2014, 15-ish. So the premise of that one was that it was a federal inmate, and he was seeking the Federal Bureau of Prisons to recognize humanism so that he could have meetings on the same terms as all the other religions, the Satanists. And actually, I don't think they recognize Satanists at the BOP, but, Rastafarians and Hindus and Buddhists and so forth. And
that was federal prison.
Yes, exactly. So we ultimately, when we won, we first had a district court judge say that we were right, sort of at the motion to dismiss stage. But then we ended up settling, and I got the Bureau of Prisons, the federal government, to agree to recognize humanism in every single federal prison. So it's it's actually a very big ruling. Yeah, it's kind of the biggest one I've had to date because we haven't had that many cases against. In fact, I think it might have been the only case we've had against the federal government. So that one I'm particularly proud of just because the reach of it is such that anytime we get a complaint from a federal inmate now saying that they won't recognize humanism at that facility, I just cite to our settlement and they say, nope, you have to recognize it. So yeah, it's pretty cool.
All right. And so that one was, okay, if it was that far back, I think I might have been podcasting for too long.
Yeah. Well, I know. I always think a couple years ago, that's kind of my thing. And then I'm like, what, 2014, 2013, what? So,
I know I talked about it on the podcast, but I've been doing this since 2012. So Yeah. All right. So then with that, does that actually create any precedent for anything else, like maybe humanist chaplains in VA hospitals or the military?
Definitely. It actually, it very much does. I mean, there's already was precedent out there, mostly in the form of like dictum from the Supreme Court saying, like humanism should be treated like a religion. I mean, I've argued it's not just dictum, but regardless, it's another, kind of solid case, and we've had several others since then, that absolutely can be applied in other contexts where a humanist wants to have the same access or privileges that religious, theistic religious people have. The same rationale would apply in those scenarios as well.
Okay. And so you're probably just waiting for somebody to try to apply for one of those positions and then get rejected and then have to reach out to you to get help, right?
I mean, not necessarily. I'm not like looking for more work. But, I mean, to be all serious, I mean, I really don't. It's better if, someone applies and then they, are like, oh, you're a humanist, so what? Like, you're just like everyone else. You get, you can be a chaplain, you can do this, you can be that. So that's the perfect scenario. In terms of setting precedent, I still have, like I said, I won another case in North Carolina involving the same issue. We're about to file one in another state. So it's all of these being in state prisons because, like I said, the federal prison has to recognize it. So there's still precedent that's being built, but hopefully we get to a point where they don't, the government just starts realizing that humanists are deserving of the same respect and dignity as theistic individuals.
And so then with the argument you go with that, because, the standard definition of religion requires a belief in a God of some kind. How do you argue that humanism is a religion or equivalent to a religion?
Yeah, that's a good question. Actually, so the Supreme Court has long denounced the idea that religion has to be defined in theistic terms. And in fact, the case I was referring to about the Supreme Court even mentioning secular humanism was a case in which the court said, for one, the First Amendment requires the government to be neutral with respect to religion and non-religion. So even if humanism isn't a religion at all, it's in the same sort of field. It's a non-religion. And you don't have to actually even fit it into that mold. There's some scenarios like in the prisons where you can't just be, atheism has been treated like a religion in the prison context, but the humanist one is even more, it's an easier case because we have things that are more analogous to, your traditional religions. We've got like the Humanist Manifesto, and we've got, professors or scholars and writings and all that kind of stuff. So we've got more kind of meat to it than just this lack of belief in a higher power. But yeah, so the definition of religion doesn't have to be, it's not theistic. With respect to the Supreme Court's decision, it was Torcaso versus Watkins. I think it was 1961. They did say in a footnote that secular humanism is a religion just like Buddhism and Hinduism, and I think they listed one other ethical culture. So we already have a Supreme Court footnote. It's just that our opponents are always arguing that it's just sort of like a throwaway sentence and it doesn't mean what we're saying it means. But I think it did, because the plaintiff in that case, Roy Torcaso, was in fact a humanist. So I don't think it was a throwaway statement, but that's kind of what we've been battling. Yeah,
and considering that the Supreme Court usually has a decent number of Jews on it, if they're parts of Reform Judaism, that's basically an atheistic religion.
Yeah, it is. In fact, a lot of humanists, in our circles are, Judaism is sort of their background, but they define themselves both as humanist and secular Jewish.
Okay. All right. And then, of course, your biggest claim to fame would be the arguing before the Supreme Court with the Bladensburg Cross case. What was that all about, and how was that?
I mean, it was it was interesting. Claim to fame. I mean, as you know, the outcome of the case was that we lost, but that was pretty much set in stone the second the Supreme Court took the case. So really, my strategy throughout the case was, just to do sort of damage control and prevent a ruling that could be much worse, and I think I accomplished that. The case was about a giant 40-foot cross in the center of a very busy intersection in Maryland. It was designated as a war memorial. It it's very, the government spent like, I don't know, something like $125,000 restoring it. So a lot of taxpayer dollars went into it. The precedent was overwhelmingly on our side. I won the case in the Court of Appeals on the idea that the government can't maintain and display large Christian symbols on government property, and especially not when they're dedicated as war memorials, because that sends a message that they only prefer Christian, soldiers to non-Christians. So we won, and then Kennedy stepped down from the Supreme Court, and Kavanaugh took the place. And then, so while our cert petition kept getting bounced off the calendar to the next week, after Kavanaugh took his confirmation hearings, they took the case. So it was like, cool. Yeah, it was the timing of it. I mean, I had a very strong feeling Kennedy was not voting to take it because he had some language in some of his rulings about how he sees crosses as different than, say, like a nativity scene, something small and temporary, something different than the Ten Commandments that has sort of Judeo-Christian roots. He's made a lot of statements about crosses that would suggest he would not want to take a case where he'd have to be kind of sort of confronting the constitutionality of a cross. So I very much feel like, this is just another example of a Trump judge, Trump having a very big role in sort of civil rights generally.
Right. Yeah. And so with that ruling, and if I remember correctly, it was something along the lines of, if it's old, it's okay.
That's pretty much the takeaway that if I were to say it in one sentence, that would be the takeaway from the ruling. I mean, there was so much, there was a lot more to it. I mean, it wasn't just that it was old. I think I think about 3/4 of the justices old was maybe a bigger factor, but so too was the fact that it was a World War I memorial. And for Justice Kagan, for instance, that was probably more important than the age of it, because to her, there was a strong connection, with the cross's use in World War I as a headstone versus in sort of another context, like an Easter cross or something. And that is probably directly related to the fact that when she was the Solicitor General, she argued that she had to do what was the case? Cross in the middle of the desert, Mojave Desert Cross case. She had to defend that cross, which was also a World War I cross. So I think she sort of also had ingrained in her mind this connection, this unique connection with World War I, which I think is so silly because there was also Stars of David used as headstones in World War I. So to say that makes it less religious is kind of bonkers to me, but that was, yeah.
Okay. So did they end up creating a new test, or was it more of a one-off?
Yeah, that's the good thing. So, like I said, when I embarked on this Supreme Court journey, my goal was to make sure that the court didn't do away with, decades of precedent that our opponents were arguing that it should. That precedent really surrounds the test that's been governing Establishment Clause cases. It was like this 3-prong Lemon versus Kurtzman test. And so, what you want in these cases, when you're going to lose, is sort of a splintered, fragmented ruling where you can't discern a clear rule. Nothing really gets overturned. And that's really what we got. There's no new test. At best, there's sort of a presumption that really old monuments are upheld. But that's it. And it's hard to say, even if that presumption applies, kind of only to ones that have a secondary meaning, like if it's a war memorial versus, an Easter cross or whatever. So, from that standpoint, the ruling is good because its reach shouldn't, in theory, it shouldn't go beyond, monuments and particularly old monuments.
Okay. So, yeah, that does sound decently narrow.
Yeah.
Yeah, unfortunately, that definitely won't help with getting rid of some of the shitty ones that have had illegal land sales to make them legal.
Yeah.
Like the one that I can see from my backyard.
Right. Which one is that?
That's the one in Boise on Table Rock.
Yeah.
It was a 1960s no-bid land sale for 100 square feet of land that just covers the cross for like $100.
Yep. I mean, we got to a point with the Bladensburg case too, where we were like, especially kind of around like we were at a point where we're like, we'd even be accepting of this like sham land transfer thing just because we don't think that further taxpayer dollars should be going towards it. It's one thing if it was just like, there's no way they'd have to spend more money, but they'd already set aside another $100,000 to continue restoring the cross. And so just like taking away the optics standpoint, there's a real tangible government, like government is spending your taxpayer dollars in a poor area where they, could build a park or something, $100,000 for, a crumbling cross. So to me, there was like, okay, even that sham land transfer thing would have been better than, letting the government continue funneling taxpayer dollars to a single religious symbol. Right. But I'm totally with you in terms of like the shamminess of those transfers. It's really kind of the worst of the better options, which, the better one is just to move it completely. But
and with the one in Boise, interestingly, in I think it was 2011, it went dark.
Yeah.
And so I'd already blogged about it once, and somebody wrote me asking, did they take it down? Because like I was the person who'd written about it the most recent. And then I finally found out, no, they brought it offline to do a like $5,000 upgrade on converting all the lighting up to LED.
Yeah.
All private money though.
Yeah,
But still,
at least if it's private money, but still,
it's 5 times brighter now.
Great.
Yeah.
Yeah.
If somebody is dealing with some kind of a church-state separation issue, with the various organizations that are out there, what would be your guidance on which organization somebody should reach out to for help?
Well, I definitely think they should reach out to us first. But no, I think, yeah, I mean, in all honesty, I think all of our organizations are really, like I said, we're fighting the same fight. And, it's obviously if it's a humanist related issue, I think we're the natural group to come to. CFI, Center for Inquiry, does more of the like sort of pseudoscience kind of debunking cases. I know Nick Little's been working on the homeopathy cases. Or homeopathy. I feel like people say it both ways, but So it's kind of like it just sort of depends. But we, like I said, we communicate so often with each other that if someone came to me saying they wanted to challenge, the homeopathic stuff at CVS, I'd be like, contact Nick Little. I wouldn't try to, reinvent the wheel. But definitely, there's really no harm if you're not sure, of contacting us first, and we can always funnel it to the other organizations if we feel like they've kind of cover that ground before us. But yeah.
Okay. And I guess it's kind of a larger issue, with now 2 Trump appointees on the Supreme Court and you having argued before both of them. Mm-hmm. How fucked are we?
I'd say we're pretty fucked because, like I said, I don't think they would have even taken that case, the cross case, if Kavanaugh hadn't been recently confirmed. I think that Kennedy, although he was still really quite conservative, he was still far better on our side than the 2 guys that are there now. And then, that's just the Supreme Court. Not just the Supreme Court, but the effect that Trump's judges and appointments are having on all of the lower federal courts has probably been more profound because, the Supreme Court can only take a handful of cases a year relative to, other circuits and stuff. So you get these horrible circuit rulings that just dead end at the circuits. And that's going to take a lot of unraveling to do as well. So it's pretty much across the board bad. And I'm just, it's a very disheartening time to be doing civil rights litigation and constitutional litigation, just because you kind of know, you kind of know your case is going to, depending on what judge you get, you kind of know where it's going to land and how, it's going to be decided. And it feels kind of like, you don't want to be too jaded, but it's not a good time.
Right. Because Congress can't do anything and the courts are incredibly slow.
Yep.
And so then does anything with the way the courts have changed, does that change how you have to do your job?
Yes, it does. We have to be a lot more careful and it's not that we were never not careful about what cases to bring, but like in terms of wanting to bring like really cutting edge cases or cases where, more gray area, like it hasn't, been really hashed out in the courts. We were really avoiding those cases unless we're in a jurisdiction where we feel very confident we'll win. Right now, it's really a matter of sticking to cases that like, if we lose, it's kind of like Handmaid's Tale. Like we can't lose these cases unless like, things just really go bad. And that's an unfortunate place to be. We're very much on the defensive side. We can't really push the needle forward. We can only kind of block it from going, like way, on the other side. So, from a strategy standpoint, and there's also just, cases, like I said, we have to turn down viable cases that we would have taken before this sort of Trump era, because not only will we lose, but we'd be creating a bad precedent that, like I said, will take even longer to unravel if and hopefully when we get a chance to. And I'm hoping that sooner rather than later.
Yeah, and that bad precedent thing is that's definitely a scary one.
Yeah, it is.
So then would you be like, say, a gray area case in Oregon? Would you be more willing to take that?
Yes, but I guess it still would depend what it is. So if it was a gray area, like, older cross kind of situation, I'd say no, just because like with respect to, religious monuments in the gray area, I think that's just not the time for it right now. But if it was, a school issue or, prisoner issue or something else, I think so, just because we would be up in the Ninth Circuit, which is still, I don't look at the Ninth Circuit as this like uber progressive circuit at all. I mean, it's kind of weird that it has that reputation because, plenty of cases have been lost there too, but
it's just such a big circuit
exactly.
that it all depends on which judges you get.
You get 3 judges, exactly. So it's really like, I'm not saying it like, I'm so optimistic in the Ninth Circuit as much as I just would feel a lot better there, even with the conservative judges that they have than in the 11th Circuit and 5th Circuit.
Yeah. Because if you got an en banc review in the Ninth Circuit, you'll probably get something more favorable.
Yeah.
All right. And how much do you take the circuit that a case is into account in determining whether or not it's, I guess, a reasonable risk to take?
Yeah. I would say it's maybe like 50%. I mean, it's hard to say because it's not just like the demographics, like who are the judges in that circuit, but it's also the precedent that's in the circuit. Mm-hmm. So if the 10th Circuit has, 5 good cases on one issue, and then the 7th doesn't have any, I'd rather be on the 10th Circuit for that issue, or, if they have a bad case, then we can't go there at all, kind of thing. So the circuit, what state you're in or what, area you're in really, really strongly dictates like what the law is. And I mean, there's just so much discord and, conflict within the decisions of the circuits on all sorts of Establishment Clause issues, legislative prayer, school prayer, monuments, and so forth. So it unfortunately is a huge factor. And I say unfortunately because I don't think that that's how the federal law should operate. I think it should be pretty uniform. I mean, even just down to like, like when you're writing a brief or something, I would get like 15 pages double spaced in California, which is really nothing, and then be in, Oklahoma and get 30 pages single spaced, both federal courts. So there's such a variety of how the justice is administered from coast to coast.
Right, and it is kind of weird how the circuits do play with that, because like you cross the border from, say, Idaho or Nevada into Utah, and it's a different circuit, and the standards are different. Yep,
exactly.
Do you think that's an issue that's getting worse now?
I don't know if it's getting worse. I don't know if I could say I've practiced long enough to know that that's worse. I mean, I think with respect to like, I've seen like little, I'm a part of several bar associations. I mean, I see there are efforts being made, I think, sometimes to try to mainstream some federal court stuff. I mean, like even just with this, like how you online file things, all the circuits I think now are on the same sort of like online filing system. So like I kind of like that's easier to work through versus before when like you'd have to go into each individual court one. There's now one sort of platform. I think they're almost all on that one now, at least every court I've been in. So like little small things like that, but they can make a difference because like, especially when you're just like a small shop like we are, I mean, it's just, for a while, it's just been myself and, our paralegal, having to relearn a new technology to file something, even if it's just an extra half an hour, can really like, kind of take too much time out of the day. So but I mean, yeah, I definitely think it should be way more uniform than it is.
All right. And how have you seen, like, I know there's been a quite the thing with Republicans intentionally trying to not let Democrats fill seats and thin out the courts, and then Trump getting a whole bunch in. Is at least all of those appointments, is it at least speeding up how quickly things move through the federal courts, or is it the backlog too far? Yeah,
I don't know. I mean, I don't think it has a discernible impact on like the backlog per se. I feel like every court I've been in is so different too. Like California and the Ninth Circuit were the fastest cases I've had. Like I won a case within like 6 months of filing the complaint, and I've had cases in like the South where I filed the complaint and like 2 years later we have like the next motion due. It's like, and California and the Ninth Circuit are like also like the most like the busiest kind of circuits and federal courts there. So I think that like they're maybe just more efficient. I don't know what the word, I don't know what it is. Maybe just the nice weather, but
maybe economies of scale.
Yeah, exactly.
At the point you've got, what is it, 80 judges?
Yeah, exactly. There's whatever they're doing, I feel like they're doing it well. And I've had cases just sitting on dockets in, like South Carolina federal court. In fact, and what's very frustrating about that is a lot of these are school cases. Mm-hmm. So the one in South Carolina is involving graduation prayer. And the problem is that like the time that the judge took to rule on back when we filed this case in like 2014, so like the plaintiffs like graduated. And so like in theory, the case, I mean, for those plaintiffs, it did become moot, luckily, because we're an organization, we have other members and, got standing through them. But like it's not just like a technical thing, that the courts take too long. They actually can directly impact the results if they take too long, and your case can become moot.
Yeah.
And then you lose. Yeah.
Could that have been intentional?
I don't think with this judge it is. Okay. I think, but I mean, no, there's times where absolutely I've thought that. And we've had 3 different judges on this case. And I think this one is not the case with, but I think the other one it might have been. But the only reason why I say that is because at this juncture, we do have standing and we're not going to lose it because we've got plaintiffs down from like the elementary schools, onwards, unless she wants to hold on to it for like 10 more years. We're okay. Fine. So I think it's more just, I don't know. Yeah, I think that's just the pace that they operate with. And I know they're all pretty short staffed too. I'm not like blaming the judges or anything. It's just the disparity in access and sort of how justice gets administered is so great from depending on what state you're in.
Yeah. And with schools, how do you get around that standing issue? Because like if it's a high school graduation, well, that's literally the end of standing.
Right. So that's the thing. So there's it's twofold. I mean, one is if you've already been to graduations are very tricky. If you've already been to the graduation and you bring the lawsuit after the graduation, you still have in almost all the circuits, and that's actually the brief I'm working on right now is involving this issue, but in all circuits but the 11th Circuit, you still have a claim for nominal damages if you encountered a prayer, say, and that violated your First Amendment rights. So you don't get to say you can't do this again, school, but you can at least get a judgment against the school district saying that was wrong. It's unconstitutional. Here's $1. But like I said, it doesn't necessarily stop them from doing it again and again and again. One workaround is, one is if you have a family that are plaintiffs, they might have younger kids in the district. You can also try to file the case earlier than a couple years before graduation. And as long as you have enough proof that it will happen to your kid when they graduate, the likelihood there's a prayer in a couple of years, you should be fine. There might be a ripeness issue, but it should be fine. Our case, we as AHA, our membership organization, and we have standing to bring claims on behalf of our members as long as they would have standing. So we have about like 10 or so members with young kids in the school district, and that was enough for us. But it is a kind of a silly rule, and there should be an exception there is an exception, and so far no courts have really accepted it for graduations, but it's the idea that things are capable of repetition yet evade review, which I think graduation is kind of a quintessential example, but they for some reason don't apply it to that.
Right. Well, and theoretically that can also come up with stuff like abortions too, right? It
does, yes. That's actually, I think, the case that the exemption to mootness sort of came out of, that particular exception came out of was an abortion case, yeah. Since
obviously if you can just delay it for 9 months, then it's moot regardless.
Right, exactly.
Yeah.
Exactly. Yeah.
All right. Okay, so we got schools, prisons, crosses. Is there a category we're missing?
Well, let me think. We did prisons. I mean, it's hard to think of things in categories because sometimes we get sort of things from kind of all over the place. I mean, there's like the legislative prayer stuff. Sometimes we get police departments doing things.
Okay, so that gives me a good question.
Yeah.
All right, what's the weirdest complaint you've gotten?
I mean, wow. I feel like we've gotten a lot of weird, really, really weird ones that aren't really like viable.
Okay, the weirdest one that you could actually take to court.
Well, weird is hard. I guess weird is still hard for this, and I've probably come up with like 5 examples after we get off. But I mean, I can tell you one that was like really egregious that I like kind of had half a mind to just go right to court and not give them a warning letter. But it was just you kind of your jaw drops when this stuff happens. It was a public school, and the Supreme Court has long said that students have a right to not participate in the Pledge of Allegiance in public school. Very old ruling, West Virginia versus Barnett, established precedent for decades and decades and decades. And we have this parent contact us saying that their child, they were, non-religious people. So they told their kid they didn't have to say the pledge. He's 6, he's in 1st grade, and he sits down, like he was told by his parents, like, you don't have to do it. He stays in his seat. And when he doesn't stand up for the pledge, the teacher picks him up out of his desk, like goes all over there and like physically lifts the kid up to stand for the pledge. And then he sat back down, and then they were sort of haggling. Yeah. I mean, you've got to be kidding me. You can't physically touch a kid and force him to stand up when you can't even ask him nicely to stand for the pledge. They can't put pressure on kids to do that. So it was so flagrant. And luckily, I mean, we had the school and everything apologized to us after we sent the letter, but I had half of mine, like I said, to just go straight to court. It just, it was a pretty bad situation.
Ooh, yeah. But you did contact the school. Did they at least take HR
definitely.
Actions against the teacher?
It was kind of a while ago. I mean, I don't think that the teacher had any real tangible consequences. I think it was a slap on the wrist for the teacher. But I do remember the school said that they were going to make it explicit in their policy, no student has to be forced to say the pledge, and obviously implied in that you can't lift the kid out of the seat to do so.
Yeah. Well, I guess that kind of leads to a question. I've got a 2-year-old, and she will be in public school in a little over 3 years. What should parents of young children do to what should we do to help our kids know their rights and get us information that we can send to experts who can help?
It's tricky because you kind of one, kids just don't have the same retention. I feel like there's only so much you can say to your kids that will get absorbed, and you also don't want them to be laser focused on I don't have to stand up or this or that. But I think that I definitely think that when it comes to the Pledge of Allegiance, that's a good one and an important one because it can be kind of educational, both to teach them that they have a First Amendment right. This sort of free exercise, you have a right to not say something. You don't have to have this sort of compelled patriotism. I think that that's one that is, something that's digestible for a kid. And, maybe with prayer too, if any teacher says you have to pray during class or this or that. But I don't know. I'm not a parent yet, so it's hard for me to know how you can what the best strategy is for communicating that. And it really is important because a lot of times the only evidence we have is through kids telling their parents stuff.
Mm-hmm.
And a lot of times it's usually like months and months after, the thing has been going on. And the parents are like, well, we would have no idea that, they were bringing, pastors to come to teach this one class or, have this prayer board in the classroom or whatever. So definitely making students aware or, kids aware of these things just to flag them if something goes on is super useful from an attorney standpoint because then we can get in faster. But yeah.
Yeah. One I had with a niece that I contacted FFRF about, this was quite a few years ago. She was going to be starting at a particular high school, and we were on the family rafting trip, and the driver for the shuttle van was a youth pastor who kept asking her questions and then told her that he would be seeing her at school.
Yeah.
And people those of us in the group just kept asking kind of some questions, and I got enough information to talk to FFRF, and they sent a letter to the school, and the school had no idea pastor was harassing students during lunch at a middle, and it wasn't even high school, it was a middle school.
Oh my God. Yeah, that's exactly.
The district had no clue.
Yeah, that's awful. It's awful. No, it's like, exactly. That's the kind of stuff where like, I feel like I've sort of seen and heard it all because of how long I've been doing this, but then we'll get complaints like that where you're just like, how could that happen?
Yeah. Like, don't you have to sign in to get into most schools now?
Yeah, exactly.
And what would you say would be like, what percentage of the cases you get are related to schools?
That's a good question. I would say like in terms of just like our intake complaints and stuff, I think like I go with close to 50% because we do also have a lot that are just related to the Pledge of Allegiance because we have a Don't Say the Pledge campaign where we encourage, students to, like I said, sit out the pledge if they don't believe in the God part or whatever reason they want to. So we get a lot of complaints just surrounding that. And that's also just in itself quite alarming how few, like given the clarity and the longstanding nature of the Supreme Court precedent on the pledge and not being forced to say it, it's pretty alarming how many complaints we get from teachers and principals and administrators that punish students or force the students to say the Pledge of Allegiance in public schools. And a lot of those came from California, where I'm from. That's pretty progressive. So it's kind of like that alone shocks me, but we get a lot of school complaints. And those ones are also tricky. Like I said, not only because you've got a child witness, where you're trying to get details like, well, how old was that person or what was the page, like what part of the Bible was it or whatever the things are. It's like, it's challenging. But the other challenging part is that obviously for extremely sound reasons, parents don't want the kid, anything to come back to the kid. And so sometimes depending on how factually specific it is, we really can't get involved publicly without the identity being revealed, even if we don't reveal it, just by like sort of process of elimination. So, yeah.
That's got to be tough doing that.
Yeah. And I mean, it's like, and just since we're on the airwaves a little bit, anyone that reaches out to us through our online form or, by email, those are confidential with us, the attorneys, and we never release anyone's name without, permission and so forth. And, you can report something and then change your mind. We don't, but it does make our, we can't just send something out, and, not be able to back it up if we don't have a plaintiff or that kind of thing.
Right. Yeah. All right. And, you do other work other than just direct humanism. You also work on non-human rights.
That's correct. Yep.
So what is that?
Yeah. So we are an organization that is working to get basic rights for, highly intelligent, autonomous, non-human animals like chimpanzees and elephants and cetaceans. And the right that we've been litigating over is sort of the right to bodily liberty, to not be owned, to not be enslaved. And we've been using the writ of habeas corpus, the common law writ of habeas corpus, as the legal mechanism to achieve this. We keep inching our way closer. And in fact, today we actually got a ruling, our case involving Happy the elephant, who is a Bronx Zoo elephant. Very sad situation, actually. But knowing we would lose the case, we got actually a very good written decision from this judge, who basically was like, I think that Happy is not just property, that she has the potential to have these sort of personhood rights, at least with respect to bodily liberty. My hands are tied because of the way the law is, but like kind of bumped us, like, when we appeal this, we have kind of more credibility going forward. So it's kind of like hard to explain what, all this stuff in like a nutshell, but the gist is that all animals in our country are treated as, they're legally considered property. They have no more rights than like a lamp or whatnot. And we're using a legal tool that had been used by Black slaves, for instance, before they were considered legal persons, they were considered chattel. And they were able to use the writ of habeas corpus at common law to secure their right to bodily liberty and their freedom. Doesn't mean that after they got their bodily liberty that they had other rights like voting or other things that we are certainly not arguing for these animals. And it's not to say we're comparing, obviously, animals to Black slaves, but the point is that there's precedent for habeas corpus to be used by an entity that's not considered a person to become a person through this writ of habeas corpus.
Heck, if corporations can do it.
Well, exactly. I mean, personhood has never been limited, or I mean, at least for our American history has not been limited to humans, and there's humans that have not been considered persons either. Like the status of even embryos and fetuses are all over the place. And then some countries like an idol or river or glaciers have been considered persons, legal persons, just meaning that there's a right that they have that can be enforced in a court of law. So that's really what we're after.
Man, how disappointing is it that in 2020 we don't have a clear definition of what a person is?
Yeah, it is interesting. It is.
All right, so there's a lot. I know there's a lot of variation in, like, just in the states I've lived in. Like in Oregon, cats aren't property. Like somebody can kill or steal your cat, and you have no recourse because cats are not property, even.
Yeah, exactly.
But a dog is property. But then there's livestock rules that are even different with enhanced protections, but also not. Yeah. So like basically there's definitely like welfare statutes that give sort of, I would almost call it like a facade of rights, because that's where people kind of get confused. But at the end of the day, your cat is still property, your dog is still property. There might be restrictions on what you as a human can do to that property without consequence. But at the end of the day, that cat is not a being that the court would recognize as its own, rights-bearing thing, entity, person, whatever have you. Right. And welfare laws really just focus on welfare. So it's like, you could have, it's not enough in our minds for the animals that we're trying to, seek protection for. Okay. And where are you drawing the line on which ones should get these rights? Or is it that you aren't drawing a line, you're just going for the most clear cases? That's
kind of a good way to describe it. I mean, we're picking plaintiffs that there's a lot of science in terms of their autonomy. And the reason why autonomy is important is because with respect to having the right to bodily liberty, if you're not autonomous, then the ability to exercise your bodily liberty is sort of meaningless. Like a chair doesn't need bodily liberty. But if you are aware that you're being confined and you have an interest in, moving about freely and you can't, then, that right should apply to you. The beauty of the common law is that it's flexible and adaptable, and it kind of grows with the times. And so when we're saying you're just giving this one chimpanzee this right, you're not giving 5 chimpanzees, you're not giving all the chimpanzees, it's just this one chimpanzee. And that's kind of the same with Black slaves, is when one slave would get free through writ of habeas corpus, it didn't emancipate every single slave from their owners. It took the 13th Amendment to do that. So so it kind of curbs the floodgate argument a little bit. And it kind of, the common law maybe science will tell us later that dogs have more autonomy than chimpanzees or whatnot. But we know at the very least that chimpanzees are so close to us, they can sign language with us. They can communicate in human language, yet they have no legal rights at all. So it is a little bit of a, I don't say lowest hanging fruit, but they're the species that I think deserve bodily liberty, at least from a scientific standpoint, the most.
So then, like with the case of Happy, are you trying to get elephants released back into the wild from zoos?
Unfortunately, that's almost impossible. They've been in captivity for so long that the full kind of wild, taking Happy back, taking Happy to Asia or Africa or somewhere is not possible, feasible, or it could be dangerous even. We have several really good sanctuaries lined up in different parts of the country for our plaintiffs. That it is the closest thing you could get to like a native habitat possible. Plenty of acreage. They don't treat them as property. They're not open for. Sometimes they'll have like a visitor day, but it's not like a zoo where there's just hordes of humans coming around and noise. So it's about the closest thing in America that you can get to, the Africa plains or wherever they would come from originally. The goal, of course, is, and I think society is shifting this way, is to just not have animals, especially, elephants and chimpanzees and orcas in captivity to begin with. And hopefully it's a problem that we don't have to work around in the future.
Yeah. And like, what about the zoos that are doing breeding programs to try to ensure that there's enough genetic diversity to keep a species around?
Yeah, those are interesting. I mean, I haven't, as a more of a rights or more of a, like, I don't know, like as an animal rights-ish person, like I don't feel like the sort of environmental biodiversity is enough to justify like sort of the torturing, if you will. I mean, I don't know. Some of those programs are probably like not as bad as others, but just to bring something into the world sort of for the sake of biodiversity doesn't excite me, because you're still kind of inflicting suffering on a living, breathing being that doesn't necessarily need that. But when we're talking about some species, I think I guess it's sort of species specific.
Right.
And what I don't like is when, groups like SeaWorld sort of do it as sort of a sham to justify having like the Shamu tanks and all that stuff. I mean, if it was purely just for, they're doing it in a way that's not how SeaWorld does it, I think that could be different. But that's more what I usually see is a zoo trying to justify keeping its doors open.
Okay. Yeah. And like, I know what I've seen with the Boise Zoo was, well, when I first went to it when I was like 5 or 6 years old, and it was concrete pens, concrete and steel, and it was despicable.
Yeah.
And almost all of those old enclosures are gone. And they've put a lot of money into expanding and improving the quality, but still, lions in a couple 100 square feet that's not a lot of space.
Right. Exactly.
All right. And how much of that do you see with cetaceans? Because there aren't as many. What is SeaWorld doing now? It's been a long time since I've been to one.
Yeah, I mean, I know that, I haven't been sort of tuned into it for a while, but I know that it's definitely, in some states, I think California, they're not allowed to at least bring in new ones, and I think they might have to shut down. It's weird how out of touch I am at the moment with where that's at, but I know that it's trending in the right direction. And more importantly, that people are starting to become more aware of the problems. If anyone's seen Blackfish, but that, this is incredibly cruel to the animals, and they don't belong in tiny little swimming pools. It's not good for humans either. The trainers obviously have suffered from that. So, I think people are becoming more aware, and then they don't want to spend their weekends or their, harder money, kind of contributing to watching animals suffer. And you can't blame people. I grew up and I went to SeaWorld, as a kid, and, there's no way a little kid's going to know that, I mean, maybe they do, but it's, one of those things that, education is just a very important component.
Yeah. And it is pretty clear that, some of these species, if we just give them some protection, they do really well. Like the gray whale in the Pacific, it's expanded enough that it's starting to colonize the Atlantic.
Right.
That's impressive.
Yeah, it is.
All right. Because, this is just a really fascinating topic for me because it's not one I've really thought about much.
Yeah.
What would you suggest for somebody who wants to learn more about non-human rights and the kind of some of the philosophical arguments around it?
So we were actually featured in a HBO documentary called Unlocking the Cage. And it's all about sort of the first stages of our project and how, our first cases went. I think that's a great kind of introduction to what we're trying to do at the Nonhuman Rights Project. You can also obviously go to our website. It's nonhumanrightsproject.org. And, we also, the president, Stephen Wise, he's written pretty extensively on this, but mostly in like law review articles and that kind of thing. So if you're more interested in just kind of getting a beginning, dabbling and understanding it, I think the documentary is where I would start at least.
Okay. All right. Yeah. And then going back to the main topic we talked about, if people wanted to find out more about what you do with the American Humanist Association, where should they go?
Yep. So we don't have a documentary yet, but you can go to our website, which is americanhumanist.org. And there's also, when you go to our main page, there's a link to the Legal Center, so you can learn more about the cases specifically through that. But yeah.
And do people need to be a member to reach out to you for help? No,
not at all. In fact, I've represented Catholics and Christians and non-humanists completely. We are like just because we're a humanist organization, the Legal Center is really confined to separation of church and state. And that benefits everyone. It's not just for atheists. Many Christians understand the importance of it for the protection of their, very religion. So definitely don't have to be a member. If we bring a lawsuit, isn't, like I said, with the mootness stuff, it sometimes can help that we are a plaintiff too, but we also file plenty of cases where AHA is not even named as a plaintiff.
Okay, very nice. So you just represent people on their behalf.
Yep, exactly.
And then if the plaintiff is a member, then is AHA a member or a plaintiff at that point?
It just depends what the issue is. But typically, that's typically our policy unless there's a good reason to not do it just for the sake of, and also for the sake of taking a little bit of the pressure off of the plaintiff, because even if they are anonymous, or especially when they're not, the media does like to call attention to, especially if they're not happy with our case, they like to sort of flame through a little bit. And so not having the individual plaintiff get all the heat is we try to do that, take some of the pressure off the plaintiff.
All right. Well, very nice. Well, thank you very much for joining us. This has been a lot of fun.
Yep. Yeah, my pleasure.
If you want to send us some feedback, you can at contact@atheistnomads.com. You can use the form on the website at atheistnomads.com/contact. You can use the SpeakPipe program to record through a web browser on your phone or computer at atheistnomads.com/speakpipe. And if you want to support the show, you can find out how at atheistnomads.com/donate or patreon.com/atheistnomads. Yeah, I'm going to get this uploaded and published and go to bed. So until next week, remember, not all those who wander are lost. Thank you for listening to another episode of Atheist Nomads. You can find show notes and contact information at atheistnomads.com. Follow us on Twitter at Atheist Nomads and like us on Facebook at facebook.com/Atheist Nomads. Please subscribe to the show in iTunes, Stitcher, or your podcatcher of choice. And while you're there, feel free to leave us a review. Theme music is courtesy of Sturdy Fred. Until next time, this has been the Atheist Nomads.